Over the past year, U.S. immigration policy has entered a phase of significant transition, and 2026 is shaping up to be one of the most important years for immigrants, visa holders, and green card applicants. The U.S. government has been gradually adjusting how immigration laws are interpreted, enforced, and processed, and these changes are already affecting people inside and outside the United States. Many applicants are confused, anxious, and uncertain about what steps they should take next. This video explains the latest updates in a clear and practical way so you understand how these developments may impact your status, your future plans, and your family. One of the biggest developments involves processing priorities at USCIS. Over the past several months, USCIS has quietly shifted how cases are reviewed, focusing more on verification, background checks, and document consistency. While official eligibility rules may look unchanged on paper, the way officers examine applications has become stricter. Even minor inconsistencies that were once overlooked are now causing delays, requests for evidence, or even denials. Applicants are being advised to double-check every form, every date, and every supporting document before submission, because processing standards are clearly tightening. Visa backlogs continue to be a major concern in 2026. Family-based and employment-based categories remain oversubscribed, especially for applicants from high-demand countries. Although some categories have seen small forward movement in priority dates, others remain stalled. The visa bulletin has become more unpredictable, moving forward 1 month and then freezing or retrogressing the next. This uncertainty makes long-term planning extremely difficult for families waiting to reunite or professionals hoping to adjust their status. Employment-based visa holders are also experiencing new challenges. Employers are facing increased compliance requirements, and audits related to H-1B, L-1, and perm labor certifications have increased. USCIS and the Department of Labor are cross-checking wage data, job descriptions, and work locations more aggressively than before. This means even legitimate workers may face delays if employer paperwork is not perfectly aligned. Many workers are being advised to keep copies of all employment records, pay stubs, and approval notices in case questions arise during extensions or status changes. For green card holders, long-term travel and re-entry rules are receiving renewed attention. While permanent residents still have the right to live and work in the U.S., extended absences are being examined more carefully. Immigration officers are increasingly asking questions at ports of entry about time spent abroad, employment ties, and residence history. Those who remain outside the U.S. for extended periods without a re-entry permit may face additional scrutiny, and in some cases, referral to secondary inspection. This trend highlights the importance of maintaining strong ties to the United States if you hold permanent resident status. Another major area of change involves humanitarian and discretionary programs. Asylum processing, parole programs, and humanitarian visas are undergoing policy reviews aimed at reducing misuse while maintaining lawful pathways. Processing times remain long, and approval rates vary widely depending on location and documentation. Applicants are being encouraged to submit complete and well-organized evidence packages to avoid unnecessary delays. Legal guidance has become more important than ever, especially for cases involving discretion rather than automatic eligibility. Student visa policies are also evolving. International students are facing stricter monitoring of enrollment status, work authorization, and compliance with program rules. Optional practical training and STEM extensions remain available, but reporting requirements are being enforced more consistently. Even small violations, such as unauthorized work or reduced course loads without approval, can now have long-term consequences. Students planning to transition to work visas are being advised to start preparing much earlier than before. Family-based immigration remains one of the most emotionally impacted areas. Spouses, parents, and children of U.S. citizens continue to receive priority, but processing delays remain common. USCIS has emphasized fraud prevention in marriage-based cases, leading to more interviews and document verification. Couples are expected to demonstrate genuine relationships with strong evidence, including joint finances, shared residence, and consistent personal history. This does not mean approvals are harder, but the process is clearly more thorough. At the policy level, lawmakers continue to debate broader immigration reform, but major legislative breakthroughs remain uncertain. Instead, most changes are happening through administrative rules, internal agency guidance, and enforcement priorities. This means policies can shift without much public notice, leaving applicants unaware until they are directly affected. Staying informed through reliable sources has become essential for anyone navigating the immigration system. Looking ahead, 2026 is expected to bring further digitalization of immigration services. USCIS is expanding online filing systems, digital notices, and electronic records. While this may improve efficiency in the long run, it also increases the importance of accuracy, as digital systems leave little room for informal corrections. Applicants should carefully review all online submissions before finalizing them. In conclusion, the current immigration environment in the United States is not about sudden bans or dramatic rule changes, but about stricter enforcement, deeper scrutiny, and higher expectations for compliance. Those who stay informed, organized, and proactive will be in a stronger position to protect their status and plan their future. Immigration is still possible, family reunification is still happening, and legal pathways remain open, but success now depends more than ever on preparation, accuracy, and awareness. The second part of today's update focuses on how enforcement patterns and administrative decisions are quietly reshaping the immigration experience in the United States. While no single law may appear dramatic at first glance, the cumulative effect of stricter reviews, increased interagency coordination, and data-driven oversight is being felt by thousands of applicants every month. This shift means immigration outcomes now depend less on speed and more on precision, documentation, and long-term consistency. One of the most noticeable changes in recent months is the coordination between USCIS, the Department of Labor, Customs and Border Protection, and other federal agencies. Information that was once reviewed separately is now being cross-checked more efficiently. Employment records, travel history, tax filings, and previous immigration filings are being compared across systems. Even small discrepancies, such as mismatched job titles or inconsistent addresses, are being flagged more frequently. This has led to longer review times, but it also means applicants must treat every filing as part of a permanent record rather than a one-time form. Another growing trend is the emphasis on intent. Immigration officers are increasingly focused on understanding an applicant's long-term intent, especially in cases involving temporary visas that may lead to permanent residence. For example, students, visitors, and temporary workers are being assessed not only on their current eligibility but also on whether their actions align with the purpose of their visa. Any activity that appears inconsistent, such as unauthorized work or extended stays without clear justification, can raise concerns that affect future applications. For adjustment of status applicants, the interview process has become more structured and detailed. Officers are spending more time reviewing files before interviews, which means questions are often more specific and targeted. Applicants are expected to be familiar with their own application details, employment history, and immigration timeline. Inconsistencies between written submissions and verbal responses can result in additional review or delays. Preparation is no longer optional, it is essential. Employment-based immigrants are also navigating a more cautious environment. While demand for skilled labor remains strong, the government is placing greater responsibility on employers to demonstrate compliance. Wage levels, job duties, and business legitimacy are under closer scrutiny. This has resulted in more site visits and follow-up requests. Workers should understand that their immigration status is closely tied to their employer's compliance, and any issues on the employer's side can directly impact their case. For families, the emotional toll of prolonged processing times continues to grow. Separation periods are extending for many applicants, particularly in preference categories with long backlogs. While immediate relatives of U.S. citizens still receive priority, processing delays remain common due to increased verification. Families are encouraged to maintain thorough records of communication, shared responsibilities, and ongoing relationships to support their petitions if questions arise. Green card holders are also facing new realities when it comes to maintaining status. Although permanent residence provides stability, it is not unconditional. Extended travel abroad, failure to file taxes properly, or lack of ties to the U.S. can all raise questions about abandonment of residence. Immigration officers are increasingly attentive to patterns rather than isolated events. Maintaining a clear record of residence, employment, and community involvement has become more important than ever. Another area gaining attention is the use of discretion in immigration decisions. While many immigration benefits are governed by strict eligibility rules, officers still retain discretion in certain cases. Factors such as compliance history, credibility, and overall conduct can influence outcomes. This means that two applicants with similar qualifications may receive different results based on how their cases are presented and documented. Professional preparation and careful presentation can make a meaningful difference. Digital transformation is also playing a major role in shaping immigration processes. Online filing systems, electronic notices, and automated tracking tools are becoming more common. While these tools increase efficiency, they also reduce flexibility. Errors entered into digital systems are harder to correct, and missed deadlines can have immediate consequences. Applicants must take responsibility for monitoring their cases, responding promptly to notices, and maintaining copies of all submissions. Looking forward, policy adjustments are expected to continue through administrative channels rather than sweeping legislation. This means changes may occur incrementally and without significant public attention. Applicants who rely solely on headlines or social media updates risk missing important details that affect their cases. Reliable information and proactive planning remain the best tools for navigating this environment. In summary, Part 2 highlights a key reality of U.S. immigration today. The system is becoming more interconnected, more detailed, and less forgiving of errors. Success now depends on consistency across all aspects of an applicant's record. Those who approach immigration as a long-term process, rather than a single application, will be better positioned to adapt and succeed. As this environment continues to evolve, applicants are also noticing a shift in how timelines are communicated. In the past, estimated processing times were often treated as rough guidelines, but now they are increasingly used as benchmarks. When cases go beyond posted timeframes, USCIS expects applicants to follow formal inquiry procedures rather than informal follow-ups. This has created a more structured but less flexible system, where patience must be combined with careful monitoring of case status. Travel-related concerns remain a critical topic for many immigrants. Temporary visa holders traveling in and out of the United States are experiencing more detailed questioning at ports of entry. Officers are reviewing prior entries, length of stays, and compliance with visa terms more closely. Even individuals who have traveled regularly without issues in the past are being advised to carry supporting documentation, such as employment letters, enrollment verification, or proof of ongoing ties to their home country, to avoid unnecessary complications. Another significant development involves public charge considerations, even though formal public charge rules may not appear dramatically changed. Officers are still evaluating financial stability, particularly in family-based and adjustment cases. Affidavits of support are being reviewed carefully, and sponsors must demonstrate sufficient income with accurate and up-to-date documentation. Applicants relying on joint sponsors should ensure that all required evidence is complete and consistent, as incomplete financial records can delay or weaken a case. The role of background checks has also expanded. Security screenings now incorporate a wider range of data sources, and processing may pause while these checks are completed. For most applicants, this is a routine step, but it contributes to longer overall timelines. Transparency is limited in this area, which can be frustrating, but it underscores the importance of maintaining a clean and consistent immigration history. Any prior violations, overstays, or misrepresentations can resurface during these reviews. Community impact is another aspect of the current immigration landscape. Local policies, state-level regulations, and employer practices all interact with federal immigration rules. In some areas, immigrants benefit from supportive local programs, while in others, enforcement cooperation creates additional challenges. Understanding how local and federal policies intersect can help applicants make informed decisions about where to live, work, or study. Legal representation is also becoming more relevant in this environment. While many applications can still be filed without an attorney, the increased scrutiny and complexity of cases mean that professional guidance can help prevent costly mistakes. Even a single error can result in delays that last months or years. Applicants are increasingly seeking legal reviews not because eligibility has changed, but because the margin for error has narrowed. Family dynamics continue to play a central role in immigration outcomes. For families with mixed immigration status, planning has become more complex. Decisions about travel, employment, and long-term residence must account for the most vulnerable family members' status. Clear communication and coordinated planning within families can reduce stress and help avoid unintended consequences. Employment transitions are another area requiring careful attention. Changing jobs, employers, or work locations can have immigration consequences, especially for visa holders tied to specific employment conditions. Notifying USCIS when required, filing amendments promptly, and maintaining valid status during transitions are critical steps. Failure to manage these changes properly can jeopardize future benefits. As technology advances, misinformation spreads more quickly. Social media platforms often amplify rumors or partial information that can cause unnecessary panic. Applicants are encouraged to verify updates through official sources or trusted professionals rather than reacting to sensational claims. Staying calm and informed is one of the most effective ways to navigate uncertainty. Ultimately, the current U.S. immigration system rewards preparation, honesty, and long-term thinking. While challenges exist, opportunities remain for those who approach the process responsibly. Immigration is not just about meeting minimum requirements, it is about demonstrating consistency, credibility, and commitment over time.